It's a common law right, which arose from the fact that if you are holding my property and you offered me service, if I'm not paying you, you have a right to that property to hold it in custody until I pay. And if I don't pay, you can dispose of it. That's what this rule is saying.
And that can stand for 28 days.
It is there, 28 days notice. All that the regulation requires of him is to give such indebted customer a 28 days notice in writing. But again, in doing this, we should be reasonable. We should not just, the man should not just be owing you in 1 week and then you give it 28 days notice. Let it be reasonable in the sense that you've demanded and the man is not responding to you. Then you give me a 28 days notice in writing, you'll be protected by this STC. Yes, sir. The STC has come into prominence now. Before the STC has come into prominence now, you could get that contract coming to you, and you are bound by it because it is coming from your client. You want to hold him, you want to do business with him, isn't it? But what the STC is telling you now is that you cannot even enter into that contract any longer. He has to know in advance that there exists an STC that you are bound by. Okay, let us imagine that the STC is here and you sign that contract and the things you are expected to do offend the STC. You have committed a professional misconduct, which the CRFFN, if they get you, they will discipline you on it. So what we are saying is that starting from henceforth, let everybody know that there is this new terms of contract that is binding. Don't write me a letter. First, look at what I'm supposed to, what binds me, the rules under which I operate. So you cannot talk from both sides of the mouth. You cannot say that there's an STC and then you also obey another contract term that definitely will not protect you. You are contradicting yourself. You are making nonsense of the STC. So, and if all of us abide by the STC as we should, if the CRFFN kind of enforces it, then you find that such contracts will not exist. Your major customers, as soon as possible now, send them a copy of the STC, which is binding, and I'm sure the CRFFN has a lot of work to do to also begin to publicize this fact, so that customs will know, police will know that every registered freight forwarder is operating under an STC. And STC is not unique to Nigeria. It's not a local legislation. It's all over the world. Check any place, you see the STC. So, why are we different? Let us not act like that old woman that was carried in a cab, in a pickup vehicle, by a friendly person. And then, when the man stopped to find out how Mama was feeling comfortable, he met her carrying the load on her head because she said she didn't want the load to be on the car. Because somebody is giving you a ride, but you still carry your load on the head, and you say you don't want it to be heavy on the car. So if we have the STC already, what is our business doing business any other way? That's the question we must ask ourselves. That's something that we should discuss in our associations. Now that the STC is here, we should begin to all operate it. And if everybody is operating it, they cannot go to a competitor to go and deal. And if you get to know that the competitor is dealing outside of the STC, then make a report to the CRFFN. The law of the Federal Republic is taken from the CRFFN. The CRFFN is making this regulation based on the CRFFN Act. So customs should abide by it. If customs does not abide by it, take them to court. Yes. Whether as freight forwarders we are bound by the CRFFN STC, yes. Those are the kind of matters that you do not need to give evidence. All you do is by way of what's that legal term? Where you just have to send the papers to the judge to read, and then he takes a decision on what the meanings are. Where the goods are perishable or are liable to deteriorate, the freight forwarder's right to sell or dispose of the goods shall arise after giving the customer a reasonable opportunity to effect the payment due and taking reasonable steps to bring to the customer's attention his intention to sell or dispose of the goods before doing so. So when the goods are perishable, it is better to act faster. That's all that it is saying.
Like in the case of Apple.
The regulations are proof of the practice wherein a freight forwarder may, acting on prior written instruction by the customer, pre-finance the forwarding of the goods. But then you must have lien on any of the goods which are subject to your pre-financing. And then not only will you collect your money, you should also collect an interest on it. Because just like borrowing the person money, it is also now the business savvy and have recourse to sound financial understanding. This is why the regulation is specific guidance provided by the regulations in carrying out a viable freight forwarding business and not without responsibilities. The irreducible minimum of warranties of the freight forwarder to the customer on demand any fund embezzled, misappropriated, or misapplied by it or by doing it is not only refunded, must still be punished for the crime of misapplication.
Sorry, sir.
Important aspect of this, of the standard trading conditions, is that there is a dispute resolution which makes it of a sort that you cannot go to court immediately. You cannot sue or be sued. The reason is this: I operate more in the alternative dispute resolution world. I'm an attorney mediator. I'm a lawyer and a mediator. And mediation is all about people sitting down together to reason like reasonable human beings and find solutions to matters. What we are saying, therefore, is that if anybody preaches this rule against you, there won't be need for, you can take him to mediation, where you have an opportunity of discussing the issues, and then you can arrive at an agreement. But where the person is stubborn and does not want to agree, then there is one more window, and that is arbitration. Arbitration is like litigation. It is a third party who is called the arbitrator that gives an award. An award is a judgment in arbitration. When there's a judgment given in arbitration, it is not called a judgment, it is called an award. And the other thing about it is that when you have arbitration in any law, it means that you cannot go to court without first doing arbitration. If you go to court, the court will ask you to go first and do the arbitration that you have. So what that means is that even the standard trading condition, because it means that when there are disputes, you should try and talk with the person on your own. If it doesn't work, then you can go to any of the multi-door courthouses. There are some courts now that are called multi-door courthouses. That is where you do mediation. And what is mediation? The parties come before a professional who is called a mediator. They state their issues, and then the professional uses his skill to try to make you to resolve amicably. He doesn't pass a judgment. He has no powers to pass a judgment. He has no powers to say who is wrong or who is right. What he has powers to do is to listen carefully to you and to discuss with you individually and to reach to show you the larger picture of why you should resolve. But irrespective of that larger picture, you still have a right not to resolve. And if you don't resolve, you ordinarily may have gone to court or gone to arbitration. But this law does not allow you to go to court because there's an arbitration clause. It means that when you cannot resolve at mediation, the next alternative is arbitration. And arbitration is a big ticket process. that many of us cannot handle. I've had to advise one or two persons who had arbitration matters, and now you go to an arbitrator and he tells you 2 million or 3 million for the sitting, and you don't have money to pay. So what do? And you cannot escape it. It's either you resolve at mediation, or you must go to arbitration. You cannot now go to court. You are caught. So that's what this law, that's the what's it called? Something you have to watch out for in this law or in this STC, that whatever operates, try and resolve between yourselves. But where that fails, go to mediation, where a third party will try to help you to resolve. But where you cannot resolve, of course, the only obvious way is through arbitration. The Council for the Regulation of Trade for Order is aware that disputes must always arise in business, and that's why they came up with these regulations, where you have to first go to it says that in the event of any dispute, difference or claim arising out of or in connection with this agreement, the parties shall meet in good faith within 1 month of the knowledge of the dispute for negotiations in an effort to resolve the negotiation is a discussion with a view to resolving, with a view to solving a problem. That is all that is about negotiation. You don't need to be an expert in it. All that you need to be is that you understand what is on ground, and you are willing to find ways. The Yorubas will say "Onokan Waja," that is not one way does not enter the market. And we are also told there are several ways to kill a cat and all that. What it means in this context is that there are several options to resolve it. So if I try to negotiate with you and it doesn't work, then we take it to the next level, which is mediation. If the dispute is not settled by negotiation within 14 days of commencement of such negotiations, or within a longer period as agreed by the parties, the dispute, difference, or claim shall be referred to a multi-door courthouse mutually agreed by the parties for mediation. In other words, if you now negotiate between yourself, it doesn't work, then you decide on which multi-door courthouse to go to. If the person is based in Abuja, you are in Lagos, you could decide to go to Lagos multi-door courthouse, or Abuja multi-door courthouse, or Abeokuta, that's Ogun State multi-door courthouse. There are many multi-door courthouses all over the place, where a mediator will now assist you to resolve. But if after the mediation you still do not, you are not still satisfied, then you go to the next leg, which is if the parties fail to reach a settlement via mediation within 14 days, the matter shall be settled by arbitration in accordance with the Arbitration and Conciliation Act, laws of the Federal Republic of Nigeria, 1990. The arbitration shall be conducted by a sole arbitrator to be appointed by the multi-door courthouse or such other office or body as agreed by the parties. You could even say, because in all of these processes, the parties are very relevant, you could say that the arbitrator should be appointed by the Council for the Regulation of Trade Forwarding, if the other party agrees. You could mention a specific lawyer or mediator that you know and say that is our arbitrator. So all of these things are allowed, but the question or the point I'm making is that with these regulations, you cannot go to court. The only time you can go to court is after arbitration. If you are still not satisfied with the arbitration, you can now go to court for the court to vary it. And in arbitration, the appeal or the variation that is done in arbitration is not a question of the judge saying, look, this was the decision that was given, it is not good enough, this is my decision. No, what the court does is just take out that aspect that I complain about. If it believes that you are right, it takes it out but will not replace it. That's arbitration for you. It will be excised, but it is not replaced. And to get that in arbitration, you have to be able to put some fundamental issues, one of which is fraud, that it was obtained by fraud. So here we are. I would advise that when we go back, we should read this.